eddoboozi ly'omuvubuka. Oli ku MRI TV, eddoboozi ly'omuvubuka. Oli ku MRI TV, eddoboozi ly'omuvubuka. Oli ku MRI TV, eddoboozi ly'omuvubuka.
At the time of Gazette, the results were different. In Mozambique, the report of people said that is unlawful for the time of officer to do, first and foremost. This decision has told you once you issue a return form for transmission of results, you can't touch it. So, my lord, I only put the final declaration where that which you are saying. No, my lord, the previous results, but that was not my point. The point was that because you do not have all 197 envelopes, BR forms. The only implication is that what you have declared a provision of results. I was merely taking you to the exception that you had asked me. That same page 751 where I am. Just below the second highlighted part, there, my lord, you are saying, unless they are cancelled. And the second respondent did not tell us that they cancelled. They did not. And cancelling, my lord, is not by invitation. We appreciate, my lord, after the second highlighted part, down there, after the second highlighted part, down there it says, we appreciate that there are cases where certain results may be missing or cancelled. And the available results are used to declare a winner. None of those applies to this case. They were not cancelled, they were not missed. So that's non-compliance, my lord. So the law commands the returning officer to only. They were not missed. No, my lord, you cannot miss something like that. This was a question of non-existence of that, not missing results. Missing results is this: that results have been declared, like in Nyaketu, Saropen. Results have been declared, here forms have been filled, along the way, the transmission. Then they disappear. The court of appeal has dealt with missing results. These were not missing because they were not there in the first place. So I'm saying this therefore does not apply to our case. And cancellation, my lord, is of course you can't do it by word of mouth. There is a procedure, my lord, if you want to cancel results. And the EC has not said, my lord, that they cancel. Not at all.
So if they were not there, what is the explanation?
What? Then the question, my lord, would be, what does the law tell them to do? I've just referred you to the law. Postpone. Yes. The vote. To the next. And how, because you see, my lord, after the election is held, the law commands the EC to declare a result in 48 hours. They still had time. Yes, so they could have held the election again in those 14 polling stations. The next day, the law gave them that option, and they did take it. Now, which brings me to the second ring of this issue, which is the issue of substantiality. Now that, my lord, I have told you and have given you authority and evidence that there was non-compliance with the provisions of the next issue is whether That non-compliance affected the result of the election in substantial. I thought I will begin with the decision of Elizabeth versus 7. We all know it's a very huge decision, but it's the excerpt I'm referring to is reproduced in the case of Bangali NALUKOOLA versus East. Basically of 201. Bangali, where that excerpt is quoted, is at page 818. But the case starts at 793. Bantalibu Isa NALUKOOLA versus EC and Oroneden, 2021. The excerpt I'm referring to of this message is captured there. Page 818. 818 of the second volume. My lord is 818. That's where the holding is, but the case starts at 790. The case of Bantalibu Isa NALUKOOLA versus GC and Oroneden. Now, my lord, permit me, my lord, to refer to that excerpt. I will not read the whole of it, but towards the end, His Lordship was trying to explain what substantial effect means. He says, that means that to succeed, the petitioner does not have proof that the declared candidate have lost. It is sufficient to prove that the winning majority would have been produced. Such reduction, however, would have to be as to put the victory. What does that mean, then, my lord? It means that in this petition, we don't have to prove, my lord, that the winner would have lost or that the loser would have won. It is enough in this petition, my lord, if we prove, and we have, that the number of people whose electoral choice was not ascertained by the Electoral Commission is greater than the margin between the two candidates, between the winner and the first runner-up. That is what we have to prove. I will have established substantial effect, my lord, if I prove that because of this number of people whose choice we don't know, because nobody knows how they voted, is greater than the margin. My lord, the margin between the first respondent and the petitioner is 8,881 votes. Those whose choice we do not know, but we are clear voted at the election, is 16,640 votes. They are almost double the margin. They are almost double the margin. 16,640. 640. But the margin.
You have the big tip there. Can you check the total? Can they use this 16,640? 640. From the 16,640.
Yes, I didn't get your question, my lord.
16,640.
Yes.
The number of total voters.
14 points. Yes, ma'am.
I want you all to check the total by checking
The tally sheet.
subtract.
So subtracting this from
By
the
taking by looking at the rows, the voters' rows.
yes, my lord.
The voters' rows.
Yes, my lord.
You can then check as total other
Okay, they'll do that, my lord, as we go. But you can also get okay, my lord. But you can also get it, my lord, from the tally sheet. The tally sheet gives you the number of registered voters per polling station and those who vote. If you look at the tally, it would be easier, my lord. But even that they can do for here. But you can easily get it from the tally sheet. Okay. I'm obliged, my lord. Now, what I was saying, my lord, is that the margin between the winner and the first runner-up with the petitioner is half of that number, nearly half of that number, at 8,881 votes. When she was here in cross-examination, she probably also said this, my lord, when she was here for cross-examination, and Mr. Baz took her on it quite a bit. The petitioner stated that in those 14 polling stations, apart from the fact that that's where she votes from, in one of them, but those were also her strongholds. And that evidence was not challenged by law. Why I mentioned that point is because the case overturned Okia Moses versus EC and Aliko Habad of 2021 turned on that point. But I refer to it, my lord, at page 954. It turned on that point. The appellant in that case said, these areas which have been excluded from voting are my strongholds. It was not challenged at the Court of Appeal, my lord. The case turned on that point. At page 954 of our bundle of authorities. Well, that's our volume 3, my lord. Atan Okia Moses versus Aliko Habad. 954, yes, it begins at 9:33, but the holding is at 9:54. In fact, my lord, when she was here, Mr. Baba said, hey, those were strongholds, okay, have the votes, have them. And she gave them the votes. So the fact that they were not, they were her strongholds was not. Now, my lord, let me also give this test, because it might be confused. How do we get substantial effect? Because I saw the first respondent trying to bring another formula when the courts have told us what. How do you get substantial effect? My lord, you do not use the number of people registered in the whole constituency. Why, my lord? For example, in this matter, the results of 183 polling stations are ascertained and unknown, and there is no path with you. So if you want to get whether those people who did not vote had substantial effect, you don't use that number vis-a-vis the total number of voters in the constituency. We are not concerned with people whose electoral choice we know. How do you get substantial effect? You get it by comparing the margin between the winner and the runner-up, who is the petitioner in this case, vis-a-vis the number of those people whose electoral choice we do not know. Therefore, my lord, in this matter, we are comparing 16,640 vis-a-vis 8,881. That vis-a-vis 8,881, which is the margin, yes, between the first respondent and the petitioner. My lord, I am not getting that from my head, but from the decisions of the Court of Appeal, two of them. I'll take you back a little bit. The decision of EC versus Mosupo, 2021. That's volume 2. That's volume 2, my lord, at page 702. page 702. That is where what I'm saying is. EC versus Mosu. Page 702.
What does that say?
Just reference my note. Maybe my note, as I look for that exact holding, I didn't appear to have highlighted it. Let me begin with the Acheng Saro Pendi at page 680. Page 680. In how we get the substantiality effect. Page 680. Ajay Saropen and another verses. When my Lord starts at just a minute. Starts at 664. But the holding about this issue, my Lord, is at page 608. I've highlighted it. My Lord, the point is this. If you look at what we highlighted, what I'm saying is, when you are getting substantiality, you do not take into account the number of registered voters in the whole constituency. So the court said this, my Lord. The land judge should have considered the total number of voters in those 15 polling stations. Here the issue was about 15. In those 15 polling stations, which was 7,000, that number, as compared to the winning margin of 7,600 without the same polling stations. And on page 680, we have highlighted that small part there. Page 680. So that's how we get substantiality. My Lord, back to Mosupo. Back to Moscow at page 702. 702. Back to Moscow at 702, my Lord. It's paragraph, I think, 445. The one that has 445 at the left-hand side. It's not highlighted, but it says the court was trying to find out, my Lord, what the number of the registered vote, what the number of those who had not been counted was, in order that they could compare with the margin. Now, my Lord, let me underscore what I'm saying. Okay. If they can be looking for it. Now, my Lord, let me underscore something as I get away from that point. And it's critical. I know that's why I'm going around and about it a number of times. The first respondent's theory is that if you want to know whether the election was affected substantially, you look at the small number of 16,440 vis-a-vis the number of registered voters in the constituency. I am saying that is a wrong reason. test. And I've given you the reason, my Lord. You do not, in that test, take into account the number of people whose electoral choice has been ascertained. In this matter, my Lord, the electoral choice that was not ascertained was only to do with 14 polling stations, whose total number of registered voters is 16,640. When we are looking for substantiality, it is that number, because it is those that we do not know how they voted, vis-a-vis the margin. If we find that those whose electoral choice we do not know is greater than the margin, then the election is put in doubt. Why? Because we do not know who would have voted what, at which polling station, what voter turnout. The mere fact that is greater, therefore, has the capacity to change the result of the election. Not change it for the winner to lose, not change it for the loser to win, but as to put the election out. That has to be underscored very critically. Now let me take you, Your Lordship, how the courts have applied this test standard. The Court of Appeal, how it has applied it, what exactly I'm saying. I'll begin with applicant. I'll begin, my Lord, with applicant. In volume 2, my Lord, the holding that I want is at page 573. 573.